Hi, my name is Stuart Voigt, and today I'm going to be doing a presentation on CrossFit trademark protection. Greg Glassman founded CrossFit Incorporated in 2000. The company was conceived a few years earlier in 1996 as CrossFit. The original CrossFit gym is in Santa Cruz, California, and the first affiliated gym was CrossFit North in Seattle, Washington. There were 13 by 2005, and today there are more than 10,000. And what I'm talking about there is affiliates, which are gyms licensed by CrossFit Incorporated to teach their training methodology. What CrossFit is high-intensity functional movements that are constantly varied. Just why this topic is relevant to business law is that CrossFit is a business. It holds training seminars every weekend in the U.S. and throughout the world. It has specialty courses such as CrossFit gymnastics, football, and endurance. CrossFit holds the CrossFit Games since 2007 to present, and as I said earlier, there are 10,000 plus affiliates, which are gyms licensed to teach the CrossFit methodology. And so CrossFit obviously generates an enormous amount of income or revenue and profit, and they do this all operating under their trademark name of CrossFit. So obviously businesses stand to gain by marketing with the word CrossFit other products. This is one example from Emergent Legal. CrossFit sued someone who was advertising CrossFit equipment. CrossFit has been involved in a number of cases and won. Many of them have been for the buying up of domain names related to CrossFit. Here's a list of cases that CrossFit has won. CrossFit has put out a guide on when you can use the term CrossFit, and just to quote this, CrossFit Incorporated leads the fight and regularly goes to battle in court to protect its trademarks and the affiliates who license them. CrossFit has 7 lawyers that work constantly to protect the name. So in this guide, CrossFit gives all these tips on how not to get into a lawsuit with them. Don't litter your website with CrossFit. Don't use CrossFit as a category of goods or services. Don't use a hyphen or space and claim it makes CrossFit a different word. So the primary statute of law here is the Lanham Act, or the Trademark Act of 1946, and it's what governs trademarks in the United States. And the issue that I'll be focusing on is the term genericide. Genericide occurs when a trademark has been judicially determined to have lost its distinctiveness as a source identifier, such that the public considers the former trademark to represent a general category of products or services, rather than a particular standard of quality and single source of such products or services. This has happened to some big names such as Pilates. And there was a case filed against Pilates, and it was found that since consumers identify the word Pilates as a particular method of exercise, the court found plaintiff cannot monopolize it. So what this was saying is that the term Pilates became so generic and common that it was determined that you couldn't trademark it. CrossFit is in the business of training, so we license the name for that purpose only and protect it to ensure it is associated with training only. So what CrossFit has done is licensed their brand CrossFit to associate only with training, and the reason for that is to prevent improper use or advertising of the word CrossFit to market different individuals' training methodologies, which could lead to the degradation of the CrossFit name and defamation of it. CrossFit has defended and will continue to defend its name against trademark infringement. It must stay vigilant, however, about bringing to court all violations of its trademark in order to fight the term from becoming generic.